Good afternoon, everyone, and welcome. Today, we are going to be talking about a very important topic and a very timely topic, which is HIPAA and health privacy, even more broadly than HIPAA, and new developments in that. What should we be looking out for this year? What's coming down the road? What should we be focused on? And I have a wonderful set of guests here, experts on health privacy and different corners of health privacy. So I'm really excited to hear about what they have to say about this question. First, we have Kate Black, currently at Hintze Law. And she used to be the chief privacy officer at 23andMe. We have Debbie Gersh, who is the co-leader of the healthcare practice at Ropes and Gray, and has been in the healthcare privacy field for a very long time, a very seasoned health privacy attorney. And Adam Greene, who also has been in this field for a very long time, beginning at HHS, and now for a long time at Davis, Wright, and Tremaine, where he handles healthcare and health privacy issues. So welcome to everybody. And I think I'll start with Debbie. I'd love to get your thoughts on what should we be looking out for this year? What's going on, and what should we have our eye on or our focus on? You're on mute.
Screw up right at the beginning. Great to be here, and thank you, Dan, for including me in this. I think one of the key issues really emanated from the tracking technology that has really come to pass, and a catch-up, I believe, that in particular the Office of Civil Rights that addresses HIPAA and the privacy laws really weren't fully equipped to handle. It was new to them in that regard, and the tracking and enforcement in their eyes was more limited. So what we've seen is a number of OCR inquiries and letters that have been received by covered entities, by hospitals and other providers, as well as business associates, looking to investigate how they use tracking technology. And I think that is going to be a significant push. It also was supported by the coincidental, not really, but by the rule, by the additional resurrection, if you will, of the FTC rule, because they can cover a lot of things that aren't really covered under HIPAA or individual entities like digital health and telehealth, because to the extent that they're not covered under HIPAA, those rules don't apply. So we have seen that missive come out as well, addressing all of those individual companies, and I know Kate and Anna will talk about those as well, that are now really subject to data breach notification laws under the FTC rule that's now been reinvigorated. And then particularly just going back to HIPAA, as I said, there's a lot of investigation going on and inquiries and letters coming from the Office of Civil Rights. And I think they're creating quite the challenge because technology, and then I'll pause so someone else can jump in, but technology has really been ahead of the laws. And they're trying to get their arms around how to regulate that and the exchange of information, and whether that information and access through tracking technology is considered a breach in violation of HIPAA or contrary to the FTC rules.
So, Kate, you look at a very different corner of healthcare and healthcare privacy. So, what do you have your eye on?
Yeah, I mean, I think that the front end data and personal information management is really going to be the name of the game in 2023. I work with a lot of technology companies as well as biotech and life sciences companies, and the intersection of the items that Debbie mentioned, as well as these state privacy laws that will now allow individuals to either have to opt in or opt out of the use of their sensitive data, is going to be really critical. Many organizations have a clear sense of where that happens in their product or in their core offerings, but throughout their website and platforms, mobile apps, chat forums, there's just not a real sense or set of controls around how that data is moved, especially health data, and even the extent to which data may be defined as health data under some of these state privacy laws, as well as whether or not some of these companies are going to be subject to this breach notification under law under the FTC's new guidance. So a lot of real deep diving and analysis on where they sit in the ecosystem and how to manage their website data.
Adam?
So, I think the areas that I'm really seeing that I think will be really interesting this next year, one is reproductive health privacy. I think after the Dobbs decision, we saw OCR come out immediately with some guidance kind of clarifying how current HIPAA applies, but it looks like a proposed rule on reproductive health privacy has gone over to the OMB, and frankly could be coming out any day now. And it'll be really interesting to see what kind of impact that ultimately has. It could be pretty limited in focus to just limiting disclosures to law enforcement and courts in certain situations. But I'll be interested to see if it really affects state preemption. I mean, currently, HIPAA, more or less, the privacy rule defers to state laws with respect to if a court orders it, HIPAA's not going to stand in the way. And this may be the first area where I wouldn't be shocked if OCR kind of upsets that balance and says, nope, we are going to stand in the way of courts seeking information. And if they do so, I think that's going to be met with a lot of controversy in light of this area. The other areas, I agree with Debbie, the online tracking. I kind of hear the Jaws music in the background. I mean, it's been lurking around for a few years. There's been these, class action suits popping up more and more. And then for my clients, the OCR guidance on the topic was really the wake-up call. That was the shark bite. That was when suddenly everyone started looking at what exactly is our marketing department doing right now? And the answer usually was, we have no idea and need to figure it out pretty quickly. So, that's been, I think, a huge area. And, the FTC's been mentioned already. I'll just say, at this rate, next year, I may be a personal health record. I mean, I think the scope of what qualifies as a PHR just keeps expanding without stop.
So I'd love to drill down on, I think, a really complicated issue and get your thoughts on the scope of HIPAA, because I think now more than ever, we are really seeing, the melding or complication of, what should HIPAA regulate? If we just say health data, that becomes tricky because so much data involves health, data that could give rise to inferences about health, data about fitness, data about life choices, all sorts of things that could ultimately, so HIPAA could cover everything if it's going to just be a broad protection of health data writ large, or any data that could give rise to inferences about health. So how do we, right now HIPAA is circumscribed in certain ways so that it does not cover a lot of companies that are in the health technology space, and should it? And then we also have issues that you've mentioned about, kind of where does the FTC begin and the HHS begin, and to some extent they have some overlapping jurisdiction. So how do we Is that good? Is it bad? Should we keep the overlap? How should we carve the pie for HIPAA? Is it a good thing to expand it, or should we kind of, keep things as they are now? Curious what your thoughts are on, if there's movement to change the scope of HIPAA, or just generally if that needs to happen soon.
I'll jump in. I guess I'm kind of content with HIPAA as it is right now, with respect to covered entities and business associates, but only to the extent that they're acting on behalf of really covered entities. I know that when Devin McGraw was back in the day at Centers for Democracy and Technology at CDT, she kind of advocated when HITECH Act came out that CDT didn't think HIPAA was a good fit for everyone, and that it really didn't make sense, because the HITECH Act actually back in 2009 called for HHS and FTC to look at this exact issue and provide kind of input to Congress as to whether it makes sense to expand HIPAA. And I think the feeling was then, and I think it's still accurate, is it's not a good fit for everything. I mean, we already see this a lot with business associates. I mean, when you think about like the security rule requiring a emergency mode operation plan, that makes a lot of sense for a hospital when you're talking about a hospital dealing with flooding and backup generators and things like that. I have a lot of business associates who are working, are completely virtual more or less, and it doesn't even really fit as well. And the more you try to take these concepts and really start applying them to other entities like health and wellness apps, I think the more we see that it's not necessarily a good fit, and it makes a lot more sense to have, I think, separate frameworks built for those types of entities and their types of operations.
Yeah, I would just echo that and say that I don't think we need an expansion so much as clearer lines about where HIPAA ends. And I do think there's room for a clearer and stronger set of regulations for non-HIPAA covered health data that can, I think, really specifically define what is sensitive health data, where does it sit, and how does it flow. But the basic structure for HIPAA just isn't there outside of traditional covered entities. And to some extent, agree with Adam, some of their business associates, even, it starts to get more questionable. I think that the new HHS guidance is really pushing the envelope in terms of defining the scope of PHI. And, I wouldn't be surprised at all if there wasn't some litigation about an overreach there, because, that data is just really outside what was contemplated for protection and exchange under the initial rules. And it's really, I think, muddied some of the waters. And that's, again, not to say that data doesn't need to be, quote, locked down and better regulated and governed. I'm all for better governance around data throughout the internet, but I just don't know that HIPAA is a good fit for that.
Yeah, I would agree. And I think when you look at the construct of HIPAA, 1996, implementation of a lot of the rules, to both of your points, the shot across the bow by OCR with their guidance is really, I think, a start of an attempt to try to grab more. They're shifting the definitions a little bit. They're shifting the burden a bit of being as to whether it's going to be encompassed by HIPAA. And I also think that in general day-to-day, and I think we have to blame more than just the government for this, I don't know if you're seeing it, but I am, where business associate agreements that were very defined and pretty limited in what they were to cover have gotten to be 20 and 30 and 40-page contracts with all sorts of other bells and whistles that are trying to bootstrap on HIPAA or on the protection of that data contractually. And a lot of times that gets down to who has more power in that relationship, right, in the business associate, and has in ways tried to fit the gaps or to close the gaps with respect, and adding contractual provisions in there. And I think the pressure, Adam, as you noted, with the Dobbs decision, the FDA and use of termination of pregnancy drugs that are also secondary uses and are used primarily for other things, how that is impacting that whole discussion and dialogue with the FTA fighting as well. So I think there's a lot to be parsed out. And I also know, Kate, to your point, that from a state privacy law issue, one of the difficulties is if you're neither fish nor fowl, if you're not under HIPAA and you have 50 state laws or 30 state laws, depending on where you are in interstate commerce and whatnot, and trying to comply with all of those laws, and then just looking maybe, okay, I'll play defense and I'll go to the most restrictive states like a California, that's just really time consuming, expensive. And so I think, there's a lot going on here that I think needs to be, and I'm sure you do too, really parsed out a little bit more, because there's still a fair amount of confusion as well.
One area I'll push back on a little bit, the new guidance on online tracking, I think, I know it caught a lot of people by surprise how broad they interpreted PHI, but I think that's been lurking there for quite a while. I mean, if you look back at guidance from, on the NIH website going back to 2003, 2005, they talk about any information that's in a context that identifies someone as a patient, they view as HHS viewed as PHI. And then in the omnibus rule, they, in the commentary, similarly said any information that's tied to a covered entity, we're viewing as PHI. I think, both of those are hidden really well. And, I've had plenty of arguments with internal general counsel and such who said, oh no, it's just demographic information, it's not PHI. I think this has been HHS's view for a while, but I think it's really, hitting people over the head now with the online tracking. But I am wondering if we're going to see our MD Anderson moment, where there was the court decision in MD Anderson where HHS has always viewed disclosure in a certain way, and the Fifth Circuit said, nope, we don't agree. We don't view it that way. And I wonder if someone's going to challenge that scope of PHI at some point. And I could certainly see a conservative judge, we saw in California, there was a decision, Eisenhower Medical Center, where the court interpreted medical information in the California law pretty narrowly and said demographic information is not medical information. And I wonder if we're going to see that court decision one day in HIPAA, where they say, nope, HHS, you're wrong. This information is not protected health information under the letter of the law.
But Adam, just a quick point, I agree with you, but PHI and whether there's a breach are potentially, I somewhat view as two different things, right?
Oh, yeah.
We've had a risk, and so, but you're making an excellent point, but the risk assessment and risk analysis, when you think there is a breach, there can be certain disclosures, right, that may not be, that could be PHI, but low probability of risk of compromise. And I think, I think that's where things start to get a little bit tricky with the blanket statements that they've been making. So yes, it's PHI, but is it a breach? And so that's where I think the rubber hits the road on a lot of these issues that we're seeing, and agree with you. Tracking technology, everyone's trying to catch up. And I know when I talk to a lot of clients, they don't even know what's being tracked and not tracked, right? Because you've got marketing doing something else. So there are internal issues as well, but it's the risk assessment that I think they're putting the further squeeze on as well. I don't know, Kate, if you see that as well, or Adam.
I mean, I think that's huge. I agree that there's that threshold question of whether it's PHI, and I think this guidance will have caught many people by surprise as to how broad HHS is interpreting that. But once you get past that threshold question, at what point does sending this information to a third party through online tracking qualify as a reportable breach? And the lack of transparency here is so challenging. We see the ones who have reported as a breach, but we don't know if there's, for every one that has, 1,000 who have looked at the similar situation and said, nope, we don't think that's a breach. And so, I think, organizations that are looking back and seeing what they've already done are really struggling with, should we treat this as a reportable breach or not?
So one thing that you had mentioned a little earlier, Adam, is the what are the courts going to do? And I think this is an issue that really affects the entire administrative state, because there's a view among some conservative judges and justices on the Supreme Court to start dismantling the administrative state. Now, ordinarily, we'd have deference to the interpretation of HHS on these questions, and that would be pretty much that, as long as it's reasonable. But now I think we're seeing a pushback by courts to be very skeptical and to take almost I saw the Fifth Circuit opinion really kind of taking pot shots, and it doesn't seem that it was really fair to to that. So I wonder, to what extent, that's going to continue that trend. And then we definitely see a very different world. And that brings me to, I'd like to discuss another point that was raised, which is reproductive freedom and issues with that, and to what extent HIPAA can change. The current approach of HIPAA when it comes to law enforcement access to information is very permissive. It essentially assumes that the Fourth Amendment third party doctrine, which says there's no reasonable expectation of privacy in records held by third parties, essentially applies to health information, because it allows law enforcement to be able to access, if it's a permissive thing, a healthcare entity can give information to law enforcement with the minimalist of procedure, a subpoena in a lot of cases. Certainly, if the Fourth Amendment were to apply there, and that would require a warrant to get this information. But HIPAA kind of doesn't really want to take that interpretation of the Fourth Amendment and just says, hey, you can just give it over whenever they issue a subpoena. I actually don't like this part of HIPAA. I think that the third party doctrine makes no sense in the healthcare context, and that it's absurd to think that that people lose an expectation of privacy in their health data because they go to a doctor. That just seems ridiculous. And that's why I think the Supreme Court never carried the logic of the third party doctrine to that extreme, because it would kind of show the absurdity of it. But that's where we are. And so you could strengthen that part of HIPAA, but ultimately I wonder, to what extent or how far you can go, because the laws that the states would be enforcing are criminal laws. So they could probably even get a warrant. So no matter what HIPAA were to do, I don't know if it could do much, but it could, maybe take a stronger stand and say, okay, we will just, bar law enforcement access to even something stricter than a warrant. But that would be taking a very bold step. And I'm wondering, is that too far, or kind of what could HIPAA do to really make a kind of meaningful, powerful stand here to truly protect this data? Is there anything?
I think 42 CFR Part 2 provides the roadmap there. So that's the rule governing substance use disorder information. And if you have a court order in a state requiring you to provide substance use disorder information, tough luck. That's the federal law. It preempts that unless the court has gone through the specific hoops with respect to navigating Part 2 requirements. And I would not be shocked to see, the statute currently provides that HIPAA preempts any state law unless it's a privacy law that's more stringent. And so there is the authority under the statute right now to preempt not just a law enforcement warrant or subpoena, but an actual court order from a state court. And I think I would not be surprised if HHS does go there and say, if Texas, for example, if a court in Texas provides a court order for a provider in California, or even a provider in Texas, to provide reproductive health information, we are going to preempt that court order and prohibit that. It would be a violation of HIPAA. And Will it be controversial? Absolutely. But do they have the authority under the current HIPAA statute to do so? I think they do.
And I think that was borne out a little bit because in looking at the OCR release in their bulletin, they did specifically talk about jobs and reproduction. So they're starting along that pathway. And we also know at the state level, in part, states who have taken a pro-choice stance have already acknowledged that they're not honoring any warrants, anything in that regard. And so I think where it gets tricky, Dan, to your point, is in states that have not accepted that, a state like Texas or whatever, and their possible persecution of individuals who have either terminated, by way of example, terminated a pregnancy or looking to terminate one or some other reason. The FDA is in the mix there as well with respect to the drugs, and so I do think it is still ripe for additional legislation or additional changes, not legislation, but changes on the HIPAA privacy side. I misspoke. And I think the vulnerability there is it could in part depend on what administration is in place at the time and how that goes through. And I think that's potentially the greatest vulnerability because there is such a split everywhere else. And so, that issue almost stands on its own, but you've seen that mentioned by OCR. And so I do think that is something that they're thinking about, as Adam said.
Yeah, I would just add, in the meantime, before we do see big HIPAA changes in this regard, it will be very interesting to see what entities and organizations make by way of public disclosures and commitments in this regard. We've seen a number of companies and even those in the healthcare covered entity space making statements about how they will or won't treat requests for reproductive health data. I think it'll be really interesting to see whether and if there's any sort of deceptiveness claims, if that ends up being handled differently than a company has purported to on their public-facing materials. So I think it's going to be a really interesting couple of years in light of the gap that will likely need to be filled before HIPAA can get changed.
Well, I think one thing too, there's a political dimension to this, which is HHS kind of needs to be careful here because there are, courts and especially the Fifth Circuit, which is very skeptical of, the power of the administrative state. And so might be, kind of ready to try to, attack this in certain ways. And so if they step, they go out in a powerful way, they're going to get some pushback from the courts, and there's that concern. There's also the concern that Debbie raised, which is, what about another administration? HHS is, generally escaped from a lot of the fate that befell other agencies like the EPA. But if HHS goes in to fight this battle, then they're going to be ground zero for an administration that wants to, dismantle that. So it's interesting politically. I wonder, if they join the fight, they could be at risk of, some kind of a retaliation down the road or pushback from courts or another administration. They may think that's a worth, jumping into that fight. But administrative agencies are not quite as strong, as statutes are. So if you had a direct statute, that would be a lot, stronger than an agency interpreting a statute or applying a statute. Is a lot weaker, I think, in terms of the power that they have. I don't know. So it seems like it's going to be interesting if they do push this and they go hard, what the implications are going to be, down the road. Are they going to get pushback? And I do this as a student of the FTC, seeing what happened with KidVid. They got a dramatic pushback on that in the 70s, and basically ever since has they still have fear over KidVid happening again, and the power that they lost from that maneuver. So there's always that concern lurking in the background. I was in the questions. I in the chat, I see that someone had asked a question about how do you navigate instances where GDPR and HIPAA could cover data. How do you separate that? How do you deal with anything? Have you ever encountered instances where both GDPR and HIPAA applies to certain activities, and then what do you do in that case?
Yeah, I mean, we deal with that kind of thing quite often. It's not uncommon that two sets of regulatory regimes apply to an organization. Really encourage organizations to create a internal privacy standard for the management, use, and disclosure of data, just like any other kind of data governance mechanism, with some of the permissible uses and processing activities being specific to one regime or the other, right? So here in the US, if data needs to be exchanged for treatment purposes, that would certainly be a non-issue, but you would have to categorize that and treat that differently if it was an EU data subject looking to exchange data in the EU. And we really work with organizations to focus on data access management, disclosure controls, and governance documents like your record of processing activities and data maps to make sure that that is all organized and coordinated internally. I would I guess finally add that they're not terribly problematic. They coexist pretty well together, I would say. A lot of the same principles underlie both laws in terms of the protection and use of data. So a little more oversight in terms of policy drafting, but not the end of the world.
Yeah, we've had similar issues. A lot of it is sometimes talking clients off the ledge that just because a European came into your emergency room, that doesn't mean you're suddenly subject to GDPR. But then we do have some clients, a minority amongst kind of U.S. healthcare providers, but we do have some that do have sufficient contacts over in the EU that they are doing studies or have specifically target marketing efforts towards EU that they do fall under both. And then it's oftentimes not realistic to have different frameworks. Like if an EU resident data subject comes through the door, we treat it this way. Everyone else is just HIPAA versus this person would be HIPAA plus GDPR. So it oftentimes will be, are we going to completely comply with GDPR? Are we going to only do GDPR where we know that we're operating in the EU and accept that there might be some EU data subjects in the US that don't get called out for GDPR treatment, and we'll kind of take our chances. So, I agree with Kate. It's not that they conflict. It's GDPR is oftentimes, I think, a higher standard here, and deciding how far you want to take that, whether you can limit it to just EU data subjects or not is sometimes the challenge.
So one thing I'd love to discuss is the FTC rulemaking this year. I'm not the FTC. I keep getting the HHS rulemaking this year. HHS is going to be making a number of changes, and I'm curious. Really, have two questions for you. One, what do you think about what's some of those changes? Anything really notable? And then two, are those the right things to focus on, or are there other things that HHS should be looking into, that changes that should be made to HIPAA that really aren't on the table? So I'm curious both what's on the table and then what's not on the table. Does anyone want to jump into this one first? Adam?
Sure. So first, I think it'll be interesting to see. I think it currently forecasts that the final rule will be coming out, possibly next month or something like that. But with what's happened with reproductive health information, I wouldn't be shocked if the 2021 NPRM, notice of proposed rulemaking, is not finalized till the end of this year or even next year, because I think OCR's focus is much more so on addressing reproductive health. And I think that's a top priority for the current director and the administration more generally. With respect to, though, when that rule finally does get finalized, I think much ado about, I wouldn't say nothing, but not much. I think there's, that rule really came out of, in my mind, kind of almost a misperception. I mean, under the last administration, you had the secretary saying, HIPAA should not stand in the way of coordinated care. And it got pulled into this kind of regulatory sprint, which is now pretty laughable with respect to that speed, to remove obstacles of HIPAA to coordinated care. I don't think there were actually huge obstacles in HIPAA to coordinated care to begin with. So, a lot of, there are things in there that have been in guidance for some time and are just being put into the regulation, like that treatment can involve community-based organizations that are not themselves healthcare providers. That's been in guidance for a number of years. It's just that's being clarified. There's, the biggest changes in my mind are probably the access provisions, although frankly, it's caused less concern than I expected from a lot of healthcare providers, because frankly, it would change the timeline from 30 days plus a 30-day extension to 15 days plus a 15-day extension available. But a lot of healthcare providers tell me they're already in states that have more stringent timeframes, so it's not actually a big deal, or that they're already meeting those timelines, at least for the run-of-the-mill sort of release of information requests. Areas where I think that they could have done more, they play around with minimum necessary a little bit and provide that there's certain disclosures to health plans for care coordination that will be exempt from minimum necessary. But in my mind, one of the biggest minimum necessary issues is that it just did not work with health information exchange. I mean, electronic health information exchange, you either get a set type of record or you get access to the entire EHR. There's not really good ways to only provide access to, if it's a broken thumb or a manual wheelchair, the information that's relevant to, a health plan being able to make a decision about that. And so I would have loved to have seen them update minimum necessary for kind of the realities of today's health information exchange, because I think it's a big obstacle right now.
Yeah, I would echo some of what Adam said in terms of not being super surprised. I was very happy to see that they did include a lot of descriptive language about the sharing of data and access to data with regards to third-party applications and third-party software tools. I do think that that's an area that HHS overall has been supportive of, but it's helpful to have in the regulation. And I think will be good tools for those health technology providers to really point to and say, yes, you have to share with us. It's clear now, there's no sort of ambiguity left.
So one thing that I kind of feel like a lot, like with what Adam said, like a lot of the rule is kind of a lot to do about nothing. It's an opportunity, after a very long time. Really the last time was omnibus, and now here we go. And there's still a lot of issues with HIPAA that need to be handled, and it's not really addressing a lot of those. And just shortening the access period to 15 days is not really addressing the major problems with access. I actually think access is a big problem. I find that it's almost laughable how many instances I have where I don't use a fax machine. It's antiquated technology. Just email it to me. But how many say, "Oh no, we can't because HIPAA forbids it"? I find this ridiculous, but nevertheless, there's a lot of misunderstanding on providing this information. Records are still very, we're still having, scrawlings of notes and a lot of paper records in an age where, so much is digital. And, some providers have a portal where you can access information and you get your records right away. You don't even have to ask for them. They're just available to you after, which I think is wonderful. And I think that, the law could really push to modernize things a lot more than they are. And if you have a lot of doctors and you've gone to a lot of doctors over a long period of time and have moved, it becomes really hard to gather all the information that you might want. So, and then a lot of it comes on these, like a disk where you can only use it under certain, browsers and other things, and on, just, or you get a DVD. If you have an Apple computer, good luck trying to find a spot to put in a DVD. So it's a mess. And I think the enforcement that HHS has done, the OCR initiative to do access, has really helped at least get the current rule to be enforced a little bit better. But I still think the rule needs to change. Access needs to be a lot easier. And I also think there's issues of patient control over data that is really unaddressed by HIPAA. It actually doesn't give patients a lot of control when it comes to data used in their treatment. And there are a lot of good reasons why patients might not want, their medical information, shared with another provider, or might want to do more than just amend their records, but correct wrong information in their records, especially when records get incredibly messy with multiple doctors and hard to diagnose conditions. It's a real mess, and I don't think that's really being addressed at all by HIPAA and by HHS. And I think that the scope issue, I think, does need to be thought about a lot more. Not that we should put all this stuff into HIPAA, but I think at least thinking about, what makes sense, and also, does it make sense that once you're in HIPAA, it's kind of largely the same set of rules, or should there be different a little bit more flexibility depending on what you're doing with the data for how HIPAA works? I think there was something that was pointed out earlier about how the security rule kind of doesn't always fit in a number of for business associates, for example. So should there be a little bit more of a recognition that HIPAA not be a kind of one size fits all approach?
One thing, Dan, with respect to something you just said, I'd love to see HHS push the technology more. It's really easy to, well, not easy, but HIPAA can be amended to say patients have more rights, but then the technology doesn't make it easy to implement that. I mean, 42 CFR Part 2, the proposed rule, scares me quite a bit because it provides more enforcement mechanisms. But right now I have clients who, with the best of intentions, do not have the technological underpinning to be able to properly safeguard substance use disorder information consistent with the rule, and kind of are relying on the enforcement discretion, the fact that there's not much risk historically. And I think, information blocking is bringing this to the front, where you potentially have to make disclosures that the patient may not even want unless the patient has requested and you've agreed to a restriction in certain circumstances. But we still have a situation where healthcare providers, even if they want to give patients more flexibility, they don't have the technological underpinnings to really effectuate that very well. And so I'd love to see ONC really continue to push health information technology through their certification standards to make it so that it becomes really easy to segregate information and allow greater autonomy by the patients in a manner that the healthcare providers themselves can easily effectuate.
So I know that some of you are going to have to go, fairly soon. So I think it would be good just to kind of go back around and just get any kind of closing thoughts or final thoughts on anything else we might want to keep our eye on, any other issues that we should be paying attention to this year. And any notable things in enforcement that we're seeing. Does anyone have anything more to add to what we should be paying attention to? Okay.
I mean, we haven't touched on it a ton, but I do think that state AG enforcement of consumer privacy laws is really going to take up a lot of space for healthcare entities, especially in California. There is not an entity-wide exemption under the CCPA, and the California AG has already started enforcing against healthcare companies, or on health-related topics, I should say, as you can see in the Sephora case. So I think that's gonna really ramp up this year, and folks really need to focus on their CCPA compliance as well as HIPAA, despite some of the broader fear around HIPAA enforcement. I think the California AG is going to be something to be reckoned with.
Yeah, I agree with you, and I think there's so many different laws, rules, and regulations to try to get your arms around that as a provider. Because even if you sit in one state primarily, there's so many other laws that can impact you through a variety of ways and reasons, treating patients out of state, et cetera. And I think there's also a funding issue. The dollars are not readily available to do this, especially in the provider industry. They're stretched enough with forms, rules, regulations. You add this cost, and then trying to make these records work technologically is a real challenge, and there's not a meaningful monetary incentive. And I'm not saying it's all about the money, but it is about the resources and the time, and then the errors that can tend to occur in that. And I also find that a lot of times in records, when you think about it, and I think everyone's implicitly brought this up, but this need to provide under the law records as soon as possible, have it posted to your personal health record or whatever, that cuts both ways, because a lot of that is emotionally misunderstood by the patient, or there's not someone there to interpret it, and they're running around, and there's a lot there that needs to be unpacked. And I agree with you as well, Kate, that the state laws have to be paid attention to. The question is, when you're sitting there nationally, or you have patients from nearly every state, if you're a cancer resource center, or someone who sees people from all around the country, how do you realistically keep up? And it really becomes more of a risk assessment and risk analysis than I can't possibly comply with every law. So you may look to California. That's one that we always have on our list, that if you have any significant presence there, maybe start with that as your threshold for compliance. But we do also see various state AGs who have their own personal cause. It doesn't make it bad. I'm not suggesting that, but what one may find important, the other may not, and they don't always. There's not a coordination there, which can be challenging. And then just going back a bit, I think we're going to have ongoing challenges when it comes to disclosure of data. We all read the markup report, watched the Facebook schools and others of the world and all that litigation. But a lot of that data is, how do you use it best? How can it be best controlled? And then who's responsible for controlling that are all issues that are out there. And with the increase in litigation, and I will say also class actions, those are also tricky, because you have to deal with that. So I think just generally from a provider standpoint, it's hard to know what Band-Aid you put on the wound, on what wound first, with limited resources.
Yeah, I've always thought that we don't do enough to, I think, there should be subsidizing of providers to try to make records more electronic and to help security. I mean, clearly security is a major issue, and it's under-resourced, and it's a major healthcare issue. All the ransomware attacks and all this this downtime and dealing with all the security breaches. I think it's a health issue, and it affects the ability to provide good care. So I think that, subsidizing that and really helping healthcare entities rather than just pummeling them if they suffer a breach would be good. And I think the law doesn't do enough of that. And also just generally, I mean, the whole impetus, I think the original HIPAA in '96 was to try to move healthcare into a more digital space, and it, still is struggling to get there. And I think things would be better if we did have more use of technology and more digital records. But there's not I think one problem is that there's not enough resources to get there. And again, that's sort of something that needs to be put into the system that could subsidize it, because it's not fully being addressed by the market. But I think it's important. I think good records are important for good healthcare. And I think that's kind of an underappreciated thing. It's not just good doctors, but also, the records and having good information and having available information, having patients have that information improves healthcare all around. So all these things, I think that the law doesn't focus enough on. How do we bring them into being beyond just using a stick? And we haven't really seen that. But but so far the stick can work because the healthcare providers are strapped.
And it's an interesting point, and I know what I'm going to say it sounds kind of snotty, but with all the fines and penalties that are assessed for like a HIPAA security breach, how about instead of just giving that money to the government, right, to force reinvestment in a security system or protocols, and say, instead of a $3 million fine, okay, give us $1.5 million, but we're going to have an independent person come in. We've seen independent auditors in the past come in, and you need to use that money solely for increasing resources. So it's an offer that we have tried to make in settlements, because I do think that helps everyone and reduces further risk. Obviously, it's not the only component, but to your point, right? If we're going to modernize this and do the things we need to do to make sure that people have accurate records and access to records and all that, we have to think a little bit more creatively.
Yeah, and for me, I'm really interested to see if anyone pushes back on the FTC with respect to their health breach notification rule. I mean, when the HITECH Act came out in 2009, I think we all had a perception of what a personal health record was. It's kind of, a digital basement filing cabinet that you put your medical records in. It's, pulling medical records from multiple healthcare providers and storing it in one place under your control. And in 2021, they put out a policy statement that more or less brought all health and wellness apps into the world of personal health records, regardless of whether the information originated from a doctor, essentially taking the position that a health app provider is itself a healthcare provider. And then we just saw, with respect to GoodRx, that they pushed it even further and more or less said, well, if you're a service that is keeping information that you make accessible to the consumer, like their past medication, prescriptions, and things like that, you're a personal health record, because that information is being maintained primarily for the user, which I thought was quite a stretch. And the question is anyone going to get to a point where they push back on this? Keeping in mind that if you're in these discussions with the FTC, they probably also have an unfair and deceptive trade practice claim that they could make against you. And so, all this has to be thought of in conjunction. So, I'm really interested to see how that plays out in the future.
Well, thank you, everyone, for a really fascinating discussion. I think we could go on a lot longer, but we are coming up on the end of our time. But thank you all. There's a lot to figure out here, a lot going on. So I'm really excited to see what happens. And also, I think some really interesting ideas here on, hopefully folks from HHS and the FTC are watching as well, because I think there's some really, productive ideas for what they should be doing as well. So thank you all for joining me, and have a good afternoon, everyone.
Thanks, Dan.